I have had a chance to study very keenly the essential character of international accountability praxis, particularly international accountability praxis in the realm of development, and how international law shapes accountability of the World Bank and IMF in their interventions in global development practices. And the following are the conclusions that I draw from that comprehensive study. It took me 4 years and 3 years and more insofar as international development accountability is concerned. One, I came to the conclusion that amid the intensification of human rights deprivations and mounting development injustice in the global south, the dominant development praxis has been typified by the marked absence of direct and distinct accountability of the World Bank and the IMF. That is one main conclusion of that comprehensive study. The second main conclusion is that the normative frameworks of international development accountability are so institutionally weak and normatively weak in that they assume a statist outlook. And by this assumption, they delegitimize any attempt to locate the causes of inegalitarian development outcomes in the character of the global development policy system. The third conclusion that emerges from my comprehensive study is that international law essentially constructs and rationalizes and legitimizes accountability avoidance, particularly when the World Bank and the IMF are the objects of censure in international development practices. That's a very critical conclusion that I made, that international law constructs and rationalizes accountability avoidance when accountability of the World Bank and the IMF are emphasized by peoples of the global south. The fourth conclusion, which is related to the third, is that this qualification of accountability for the World Bank and IMF in international law is part of how the legacy of international laws, the international law's legacy of the hegemonization of development on the one hand, and on the other, the sustenance of relations of domination and subjugation. That subjugation that targets the people of the global south. Such a qualification of accountability implies that international law tends, or explains that international law tends to formulate discourses that delegitimize any attempt to locate causes of inegalitarian development outcomes in the character of the global development policy system. It is to be noted that this delegitimization proceeds through shifting the accountability of these institutions completely to the agency of the state, almost always of the third world. That is to say that international law has constructed a normative framework and practice whereby poor and indebted countries, only poor and indebted countries in need of financial assistance tend to be held more accountable. And this accountability is towards the IFIs, international financial institutions, than to their own citizens. Related to that, therefore, we notice that even the internal accountability mechanisms and processes of these institutions are only meant to create accountability of these institutions to themselves and not external accountability to users or the beneficiaries of their development interventions. The other conclusion that derives from this is that accountability regimes seems to be so Western derived in that they are constituted by certain explicit and implicit rules, norms and procedures, institutional practices that are ill-suited to aid the securement of the kind of development justice that the people of the global south deserve. Therefore, one would be safe to say that they cannot sufficiently assure the protection of the people of the global south from the vagaries and harms that are causally linked to development interventions of the World Bank and the IMF. By such institutional flaws of the design of international accountability systems, it is to be noted that even the internal accountability mechanisms of these institutions exemplify international law's implication in the immiseration and deflection of claims of justice and emancipation from the marginalized social classes. This is particularly to be seen in the way the inspection panels of the World Bank is designed only as accountability mechanisms of the World Bank to its own rules and procedures, and not accountability of the World Bank to the people that are affected by the development of these institutions, development practices of these institutions. Now, the other conclusion which I think is very intriguing, and this emerges from very comprehensive and close analysis of the very character of international doctrines of accountability, is that if you read very, very keenly, you will notice that international law has a peculiar tendency of making proclamations of universality of doctrines. For example, the doctrine of sovereignty. Yet, these doctrines are brokered without, I think that's what my study concludes, they are brokered without or even in total disregard of divergent contexts and experiences of different peoples. For example, sovereignty amongst the African people is communitarian. It is not in the liberal sense as the Western conceptualizations want us to understand it. Yet, the promulgations of some of these doctrines takes that absolutist stand of Western's conceptions of law that completely ignores other worldviews. For example, the third world approaches to international law. To be seen very categorically as a critique of this absolutist character of international is that this tendency, inarguably, is how we come to appreciate the seeming universalist content and character of modern public international law doctrines, with their classical antecedents, which reflect European or Eurocentric, absolutist, and monocultural conceptions of the universe. It is this monoculturalism and a Eurocentric understanding of international law that cements a universality dominated by European socio-economic, cultural, political biases, values, and even self-images. The fact is that, the undeniable fact is that international law doctrines and the superstructure of development, especially postmodern institutions of development that they construct and reconstruct, are not fashioned to reflect the diversity of people or complexities underlying the divergent value systems of these people that we're talking about. This points to the incompleteness of international law. Thus, because some international doctrines cannot lay claim to the universality necessary for their legitimacy, however normative their justifications, they constitute a flawed normativity, in my view, and a flawed universality. It is this deformity that supplies their discrepancy with the task of delivering accountability for developing justice. Now, this point is very, very deep. If I had a point, I could explain. One way of explaining this is to look at, for example, the doctrine of accountability of international financial institutions within the regime of the draft responsibility of international organizations for international wrongful acts, called the RIO of 2011. Now, that regime assumes that international institutions can also, in their development practices, cause harms that impact directly on the people, that they can be held accountable for if you trace the causal chains of harms. Now, in the international economic systems, this is something that I have studied very, very keenly. Causal chains of harms tends to be so intermingled, so interlinked, that one cannot possibly point at one actor to have caused the harm. Neither can you even trace the causal chains of harms. It is therefore erroneous that one can assume that you'll be able to trace a causal chain of harm to a particular international institution and therefore effectively hold it accountable. That is not possible because of what I call the intermingle effect. Because of such quality, international law has either to fail to secure economic justice. Economic injustices often inhere in the supranational economic systems and not in the domestic systems that have got clear-cut and traceable causal chains of harms. In the international economic systems, causal chains of harms are interlinked, intermingled, such that they are indiscernible. There cannot be a trace of one particular actor. The other conclusion that I think is very crucial, that besides, contemporary regimes of accountability fail to take account of, this is what I'm talking about, of the determinative role of global factors and their intermingling with national factors to produce harmful outcomes. The contemporary regimes of accountability often deploy an interactional account of the globally embedded injustices. And in so doing, they view such injustice as wrongfulness or human rights violations, which are to be traced to a particular actor. Yet they do not render a proper account as to the rootedness of such harms in the global policy system that makes them indiscernible, indeterminate, and cannot properly be differentiated for purposes of allocating direct and distinct accountability of institutions. The other conclusion, which I think is very crucial, that because of the status character of international law, or in its characteristic incompleteness and the instance of utopianism, international falls far short of providing an adequate framework for addressing the issues of direct and distinct accountability of international financial institutions. If you read my dissertation, you'll be able to discern clearly what I'm talking about here. The conclusion, I think the overarching conclusion, is that one would therefore be impelled to call upon international lawyers to fundamentally rethink the relationship between international law and development, particularly in relation to the way international law forges norms that facilitate accountability eclipses and displacements, accountability deficit and dysfunction, accountability depletion and obliteration, particularly in the realm of international financial institutions' interventions in the global economy. And as we do this, I add that there must be an awareness that we cannot fully rely on international law or its iterations as the sole discourse for the third world emancipatory struggles against structural injustice. This is deep, this is heavy. In another clip, we'll be able to explain what we mean by this. But for now, those are the conclusions, or my own conclusions, on how international law shapes accountability discourses, particularly in relation to the intervention of the World Bank and the IMF in the global economy.